Hey, are they gonna allow me to read? I have a little something to read. Is that all right?
Yeah, at the end, you'll do it.
Okay.
Okay.
Thank you.
Yep, you're welcome.
Good morning, Mr. Murphy.
Good morning.
We're gonna get started in just a moment. I have your PO who just connected. PO Desena, can you hear me?
Yes, I can hear you.
I believe you press *4 to unmute. You're still muted. If it's not *4, it's *3 because I just want to make sure you're able to unmute before I get started. Hey, Kristen, can you hear me? All right, PO Desena, I see that you reconnected. I just need you to press *4 to try to unmute. There you go. Can you hear me?
Hi, *6.
No, it's okay.
Hello.
Good morning. My name is Professor Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Erik Murphy, inmate number 315761. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video of the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Erik Wayne Murphy, 315761.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Murphy.
As well as your parole officer.
Parole Officer Jennifer Desena, Waterbury Parole.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Murphy and PO Desena, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
Thank you. We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. P.O. Desena, starting with charge 1, obedience to the law.
Hi, good morning. On November 16, 2024, you were involved in a domestic disturbance with your girlfriend at her residence. You threw her TV on the floor of her bedroom and then went to her kitchen and subsequently threw pots of corn and rice across the floor. You were arrested by warrant from Waterbury Police Department for the charges of disorderly conduct and criminal mischief.
The state has filed the following exhibits, starting with Exhibit A.
Remand to custody. Exhibit B, parole conditions. Exhibit C, notice of parole violation. Exhibit D, parole violation report. And Exhibit E, Waterbury Police arrest warrant.
The state has filed an addendum to Exhibit D, which states on January 6, 2025, Mr. Murphy was convicted of disorderly conduct and was sentenced to unconditional discharge. The charge criminal mischief third was nollied under docket ending in 995. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and at this time the state will have an opportunity to present evidence and speak to any of the evidence submitted. P.O. Sonia?
Hi, yes. Just to speak on, I supervised Mr. Murphy. I took over his case when my partner, Officer Rodriguez, went out on leave for a little bit. And when I first took over the case, he was working full-time and living in a rooming house and was not on GPS anymore, completed his GPS dip. He was on GPS due to weapon charge. So when I began to supervise him, he was working full-time, living in a rooming house. At the time of his remand, he had lost his job and was still continuing living at the rooming house. I don't have any other misconduct that I did not give him any misconducts when I was supervising him. But that's all I can really, say. But at the time, he was arrested by warrant for the physical domestic with his girlfriend. And I'm thinking that's about it. When he does come back out on supervision, I'm just recommending he be stipulated to domestic violence and strict no contact with the victim and GPS placement.
Okay.
Thank you.
Mm-hmm. It is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. I'm not sure if I misheard P.O. Desena, but I think she just categorized the incident as a physical violence incident. If that's what she said, I would just disagree with that. There is no allegation of physical violence here. My client did enter into that plea agreement, received an unconditional discharge on a disorderly conduct, which is the lowest misdemeanor that you could have received a disposition on. In addition to that, he was eligible for the Family Violence Education Program and had apparently had intentions of applying for that program when his case was moved to an earlier date, and he was told that this disposition was available to him and urged to accept it as by his counsel. I mean, unfortunately, I didn't represent him in court, and that's not something that I would have done. I would have applied a client who was eligible for a program. He has no history of domestic violence whatsoever, and he was eligible for that program. And as you're aware, he would have received a dismissal of the charges, and they wouldn't have been on his record had he gone forward with that. So I just think it's unfortunate. I know my client has reached back out to the attorney in court and hopes to go back to court, have the plea vacated, and apply for the program in instead, but I don't think he's had much success with hearing back from the attorney. So I think that's an unfortunate situation, but here we are today. So I just put those comments on the record in regards to the charges. Thank you. Nothing further.
Thank you. Officer, anything further?
No, I do not. You know, just his housing. I'm not sure if he lost his rooming house since he's been incarcerated. So if he did, I'll also recommend halfway house placement.
Okay.
And
Thank you.
nothing very much.
Okay. And defense rest, correct?
Correct.
I have something to read if possible.
Yeah, that's at the
Yeah,
end.
well-
That's at the end.
If it's-
Okay.
So it's not regarding the allegation, correct? It's regarding you want to make a statement?
Correct.
Okay, yeah, so I'm going to just make, going to my finding regarding the allegation of obedience to the law.
All right.
I'm just going to take a moment before I announce my finding. On charge 1, obedience to the law, I make a finding based on Mr. Murphy's conviction as well as State's Exhibits B, D, and E. That concludes the fact-finding portion of the hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. Officer, do you wish to make a statement regarding Mr. Murphy's background and history at this time?
No, I believe I mentioned everything that I, needed to
Thank you.
mention. Thank you.
And counsel, do you wish to make a statement regarding Mr. Murphy's background and history at this time?
Yes, thank you. My client is 45 years of age. He's single. He does have 4 children, a 19-year-old, a 13-year-old, a 12-year-old, and a 3-year-old, all of whom he maintains a good relationship with. He's a high school graduate of Holy Cross in Waterbury, and most recently was taking an information technology certificate program at Housatonic Community College in Bridgeport. He does have a support system in the community by way of his fiance, and her name, I'm just going to indicate, is stated in Defense Exhibit 1. Just for purposes of the domestic violence conviction, I just won't indicate her name on the record. However, her initials are TH. He was in the community, I believe, for over 23 months. He indicated he had gone out to supervision sometime in November of 22, though I believe the paperwork indicates he began parole supervision in March of 23. So I'm not sure if he went out prior on a community release situation or not, but he indicates he has been in the community since that November of 22 date. So I believe that's in excess of the 23 months. This is his first violation of parole supervision. During the time period that he was on supervision, he successfully completed the Isaiah halfway house in Bridgeport and then was able to self-sponsor in Waterbury. He was working 7 days a week at Stop and Shop in Norwalk, doing Peapod. And he held that employment for 1 year and 9 months. And though his PO indicates he lost his job, he had to leave his job because he was now living in Waterbury and commuting to Norwalk by train. And that was just very difficult for him. And so he made the choice to leave that job and to start seeking alternative employment. And so I don't look at it as a situation where he lost his job. I think he had to make a choice. And that was obviously a very long commute. Also, during his time period on supervision, he completed outpatient services at Recovery Networks of Programs J Brothers Unified Resource Center in Bridgeport. The documentation that our office received indicated that client showed high levels of participation, engagement in his recovery. He also attended Project Safe Neighborhood. And as his PO already indicated, he successfully cooperated and completed the GPS monitoring. That was a condition based on his underlying conviction. During his time period that he's been in the Department of Corrections, not necessarily this period of time, but also taking into consideration this period of time, he's always used his time wisely. He's completed the Voices program. He's completed Tier 2, and presently he's been attending New Thoughts, which is formerly Good Intentions, Bad Choices program. He attends that twice weekly. He was recently accepted to the Concrete Vocational Village program, which guarantees employment with the Department of Transportation upon release from DOC. So he has been making good use of his time. Upon reinstatement to parole, he is asking to be placed in a halfway house in the Waterbury area in the event that he cannot return to his self-sponsor. And he's also looking to return and complete the IT certificate program at Housatonic Community College. He's open to all employment opportunities, and obviously he would specifically like an opportunity with the DOT, as well as employment within a group home that's located in Waterbury, where he has a connection through his girlfriend's mother, who is employed there. Taking into consideration all the circumstances here, my client has been in custody for approximately 3 months. We would be asking that he be re-paroled at the next available date. Thank you. And I believe he does want, unless I've covered what you wanted to say, Eric, do you still want to provide a statement?
I do want to provide it, if you don't mind.
Yep.
Thank
Go
you.
ahead.
Good morning. I would like to thank you for your consideration and taking the time to hear me out. I humbly implore you to keep in mind that every case is different and has its own unique facts and characteristics, just like each and every individual that appears before you. First and foremost, I take complete and total accountability for my wrongdoings. I was frustrated due to several employment opportunities that fell through. In no way is that an excuse for my actions, nor am I attempting to justify my behavior. I simply was overwhelmed by my predicament and I reacted inappropriately. At no time did I have any intention of harming my fiance in any way, shape, or form. In fact, I am 45 years old and I have zero history of violence. I'd like to reiterate, zero history of violence, while incarcerated or otherwise. I wrote this with the hope that you would keep an open mind and an open heart as well. I do feel as though in some ways you have already formed an opinion or made a predetermined decision. So maybe what I have to say is moot, but it means too much for me not to address. I have read Parole Officer Desena's recommendations, and although I agree that a domestic violence program is a reasonable stipulation, I emphatically disagree with the no contact order and find it to be a complete miscarriage of justice due to the following. For one, my fiance has written a letter on my behalf and clearly stated her stance is to remain in contact with me. Second, not only am I willing to take the domestic violence program, in addition to therapy, my fiance would like to take couples therapy as well as give me her full support and participate in the DV program if necessary. My third and final point I would like to emphasize is that this is my first domestic violence charge. Therefore, I was technically eligible for the family violence program, in which case I would have had a second chance. My attorney advised me to plead guilty to the disorderly conduct instead of offering me the program. I later received counsel from my PRU public defender and was told that I should have been given the program, which in doing so would have rendered the no contact stipulation unjustified. In conclusion, I lived in a woman's battered shelter as a child and witnessed my mother being beaten and abused. I may be a lot of things in life, but a woman beater I am not, and I adamantly refute anyone who thinks or says otherwise. Thank you for giving me a chance to state my case and present my facts.
And if I can just thank you, Eric. If I could just add one thing, my investigator did reach out to TH, who did indicate that she absolutely wanted to have contact with my client and wants to continue to have contact with him. They are in a relationship, they're engaged, they do plan to have a future together. I would ask that any orders regarding his contact, at the very least, be with the PO's permission. We would be objecting, obviously, to a strict no contact order here. He does have no history of domestic violence, and the allegations here simply don't even involve any allegation of physical violence. He's simply throwing things around a room. It simply doesn't, in my opinion, meet the criteria. Obviously, had the court felt it was appropriate, they could have issued a protective order. They could have placed him on probation, had a protective order or a standing criminal protective order. Any of those things could have been put in place had they felt it was appropriate, and simply he was given an unconditional discharge. So I would have to make the assumption that those things were contemplated by the court. Thank you.
Thank you. Officer, anything further?
Oh, yes, I have a few things after Mr. Murphy read his thing. So never once, and I mean, I'm going to reiterate, never once did he reach out for any type of assistance or any help due to him stating that he was stressed and he was dealing with a lot of stuff in his life, hence the reason why he stated he no longer wanted to work, or the reason why the incident occurred, because he was stressed out. So I just want to reiterate that never once did he reach out for any type of counseling, or never once reached out to myself to speak about what was going on in his life. Every time I spoke to Mr. Murphy, he never once stated that he was engaged or had a fiance. I I actually, every time I met with him, I would always ask about his girlfriend, and he stated that she lived down near the Route 8 area. So never once did he mention that he had a girlfriend A in Waterbury or B, a fiance in Waterbury. So just recommending that still have a strict no contact due to his inability to deal with stress and anxiety, and then resorting to that type of action that he took while throwing the pots and pans while dealing with his aggression. So I recommend that he does DV or anger management before we allow him to have any type of contact with the victim, so he can learn some tools on how to, deal with stress or anxiety, what he's going on in his life, rather than resorting to throwing things in a residence. So I'm just going to state that, and that's it. Thank you very much.
Thank you. Counsel, anything further?
No.
Okay, thank you. I'm just going to take a moment before I announce my recommendation. And just to confirm, TH is your girlfriend who was involved in this incident, correct, for the violation?
Correct.
Initials TH, okay. Okay, Mr. Murphy, I have that you've been in the community for about 2 years. You were in the community since November 2022. In that time, you received, I have no reports of any misconducts, no prior violations, other than this situation here where you received the conviction of disorderly conduct with the unconditional discharge. Taking all what was said in testimony here today into consideration, I recommend revoke and re-parole on February 27th, 2025, which is an approximate 3-month sanction with the following conditions: domestic violence, no contact with co-defendant Nyasia Baker, halfway house placement, and a general no contact with TH without PO permission. My findings and recommendations will be forwarded to the board, and you will receive an official written decision from the board, and your board review is scheduled on February 27th, 2025. So on that day, the board's going to take a look at your case. My recommendation is for you to be re-paroled on that date, but because you're on discretionary, it's an on or after date. So if the board agrees, you will be released on or after 2/27/25. Now the board can agree with that recommendation, or they can exceed that recommendation if they don't agree. And if they don't agree, another hearing will be taking place for them to express why they want to have additional confinement. But the decision will be made on February 27th, which is next Thursday. Okay?
Thank you.
Any questions?
No.
Okay, thank you.
Thank you.
Enjoy
Thank you,
your day.
Desena.
Thank you, everybody.
You're all
Thank you. Have a
set.
good day. Bye-bye. Thank you.
Eric, you're all set. I think you can go let them know that you're all done, okay?
Thank you.
All right, you're welcome.
Attorney Jones, I just received an email from Osborn. They're having some technical issues, so they're restarting the system. So she'll send me an email when we're able to connect.
Okay, thank you.
No problem.
I'm sitting here, I'm just eating.
No problem.
Okay.
Good morning, Officer Williams.
Hi, I'm so sorry.
Look, I just appreciate you reaching out, sending the email. You have no idea. Thank you so much for that.
No, I appreciate you leaving your name on the docket because there's no way I would have been able to call you guys.
So who we have? Mr. Miller.
Miller, yes. I'm just waiting for him to come down the hall. They just let him out.
Okay, awesome. Thank you.
Thank you.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning George Miller, 163184. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
George Miller, 163184.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defenders, Parole Revocation Unit on behalf of Mr. Miller.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Miller, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you very much. First, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
I do.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, absconder. On September 28th, 2024, at 9:45 a.m., you signed out of your only parole-approved residence, Fellowship Halfway House in Groton, on an approved community pass to Smashburger in Waterford. You failed to return to the halfway house on September 28th, 2024, or at any point thereafter, and your employer reported that you never showed up for your shift. All attempts to locate you were unsuccessful, and you have made no attempts to contact the halfway house or parole, indicating your intention to purposely evade parole supervision. Your whereabouts in the community have remained unknown since September 28th, 2024. Charge 2, obedience to the law. On November 18th, 2024, you were arrested by the Waterbury Police Department and charged with violating Connecticut Journal Statute 53A 108, criminal trespass second. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, signed PCS conditions. Exhibit C, notice of parole violation and parolee rights. Exhibit D, parole violation report. Exhibit E, halfway house placement. Exhibit F, Fellowship Halfway House incident report. Exhibit G, Waterbury Police report. The state filed an addendum to Exhibit D, which states on January 2nd, 2025, Mr. Miller pled guilty to the charge criminal trespass second. He was sentenced to 6 months jail, execution suspended, followed by 1 year conditional discharge, under docket ending in 866. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification purposes?
Yes.
Defense has also filed parole, Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Thank you. I have no comments as to the 2 charges.
Thank you. So I'm going to take a moment before I make announce my findings. On charge 1, absconder, I make a finding based on state's exhibits B, D, and F. On charge 2, obedience to the law, I make a finding based on Mr. Miller's conviction, as well as state's exhibits B, D, and G. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, thank you. My client is 53 years of age. He's single. He does have 2 adult sons. He has a high school diploma. He holds certification in hospitality. He has 2 different certificates. He does live with both mental health as well as substance abuse issues. During the time period that he was on parole supervision, I believe he was in the community for approximately 6 months, having initially been released to transfer parole on March 27th of 24. This is his first violation of parole. He was utilizing a halfway house for housing. He held employment at various jobs: Burger King, Wendy's, Moe's, Chili's, Marriott Hotel, the Spot Cafe, and most recently he was working full-time at Smashburger. Mr. Miller has maintained sobriety for approximately 7 years, including residing in managing a sober house. He participates in Narcotics Anonymous. He was participating in biweekly individual therapy at Waterstone Counseling Center. When he is paroled, he's asking to be placed in a halfway house in the Hartford area as his first choice. Secondary to that, he's indicating the Bridgeport area. He is amenable to all employment opportunities, and I think it's obvious that he always has a way to find employment. So he's not someone who's not actively looking for employment. He always finds employment. He's amenable to all treatment recommendations, and he's interested in reestablishing clinical services in the community by way of individual counseling and medication management. He does take medication presently to manage his mental health symptoms. So we would be asking, I believe he's been incarcerated now for approximately 3 months. I think it might be exactly 3 months. We would be asking that he be reinstated to parole at the next available date. Thank you.
Thank you.
And I don't know, Mr. Miller, did you have something to add?
No, I mean, unless it's necessary. I mean, this whole thing started, I was just really had too much time on my hands before work, and I was trying to be sneaky, the time got away from me, and you know what I mean. I was you know what I mean, embarrassed, you know. So the parole called me. I was turned myself in, but I got caught in the building in Waterbury before I could turn myself in. You know.
Thank you for your candor.
Thank you. I'm just gonna take a moment before I make my recommendation.
Thank you.
Mr. Miller, I see that you've been in the community since May 2024. You were supervised in the community for about 4 months prior to you absconding from the halfway house. Your whereabouts were unknown for approximately 7 weeks. In that time, you did get arrested. You received this conviction for criminal trespass second, which is 6 months suspended, 1 year conditional discharge. Prior to absconding, I don't have any misconducts reported on you, for any behavior while in a halfway house or anything like that. So taking all that was presented today, as well as even your testimony today in consideration, I recommend revoke and reparole on February 27th, 2025, which is an approximate 3-month sanction with the following conditions: no contact with co-defendants Dimitri Heath or Anthony Wade, a general no contact with Jesse Spence, Jennifer Martinez, Ashley Chase, Michael Thompson, Eugene Foote, Jamar Redding, and Lorenzo Case on halfway house placement. My findings and recommendations will be forwarded to the board, and you will receive official written decision from the board. And your board review is scheduled on February 27th, 2024. Or 2025. So on that day, the board is going to take a look at your case. If they agree with my recommendation, which is on February 27th, that's an on or after date, being that you're on discretionary parole. If they don't adopt that recommendation and they want you to exceed that recommendation, another hearing will be taking place for with you and the board to justify additional confinement, being that you are on supervision until July 2025. So that's if they want to exceed. But if they don't want to exceed that recommendation, you will be released on or after 2/27/25. Okay.
Thank you very much.
Okay. Do you
questions?
understand that?
Yes, I do.
Okay. Okay. If you have any questions, you can always call me. Okay.
Okay, I still have your
Okay.
number.
Okay.
So I'm all set now.
Yeah,
Yes.
you're all set. Thank you.
Okay, thank you, Miss.
Thank you. All right. Thank you, P.O. Saunders.
No problem. Have a good one.
You too.
All right, thank you. You guys have a
Have
good
a good one.
day. Thank you too.
they don't do, you gotta have a project on Friday.
Good morning.
Good morning.
We're gonna get started in about 4 minutes.
Okay.
Thank you. Good morning. My name is Pro Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Daniel Riles, inmate number 235-288. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Cheshire Correctional Institution. Please state your full name and DOC inmate number for the record.
Daniel Alexander Riles, the second, 235-288.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing, which has 3 purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Riles, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
I would like to proceed without counsel.
Okay, thank you. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges of the state your parole officers bringing against you and the information underlying each charge. Charge 1, obedience to the law. On January 13th, 2025, you went into 48 House Street and walked upstairs to the Sierra Center halfway house on the 4th floor. You were previously prohibited from the Sierra Center halfway house and its premises due to intimidation and threats that you made toward a Sierra Center halfway house staff member. Due to your actions, Connecticut State Police issued a warrant for your arrest for criminal trespass, stalking third, breach of peace with a $25,000 bond. Charge 2, search. On January 17th, 2025, parole staff instructed you to sit in a chair in order to search your shoes. You refused to have a seat in the chair. You also refused to remove your shoes. This violates your special parole conditions that state I will submit to a search of my person, possessions, vehicle, residence, business, or other area under my control at any time, announced or unannounced, with or without cause, by parole or its agents to verify my compliance with the conditions of my parole. Charge 3, no consumption of alcohol. On January 17th, 2025, you rendered a urinalysis. Your specimen number P3482418 was sent to Premier Biotech Labs for alcohol testing. On January 22nd, 2025, Premier Biotech Labs confirmed that your specimen was positive for alcohol. The state has filed the following exhibits. Exhibit A, Statement of Understanding and Agreement Conditions of Parole. Exhibit B, Remand to Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Notice of Parolee Rights. Exhibit E, Parole Violation Report. Exhibit F, Decision Information Summary. Exhibit G, Connecticut State Police Arrest Warrant. Exhibit H, Connecticut State Police Report. Exhibit I, the Connection Sierra Halfway House Incident Report. Exhibit J, Notice of Parole Violation. Exhibit K, Premier Biotech Labs Toxicology Report. Exhibit L, Offender Misconducts. And Exhibit M, Revocation Summaries. Mr. Riles, did you receive the Notice of Parole Violation Report, and the marked for identification purposes? It should have been like a parole package of evidence. Did you receive that?
After the continuance of this, my original preliminary hearing was scheduled on the same day as my court date. So on the 5th, I got that package. But the original notice of violation only had the one charge. I understand the urine took time to develop, so that's understandable. The other charge of refusing to let them search, I was in cuffs, I was in their custody. Technically, I was in the state police custody because he read me my rights and said.
Well, Mr. Riles, you're going to have an opportunity to testify. I just want to know if you received the evidence.
All right, yeah, after the original preliminary hearing court date, yes.
Okay, and did you have time to review it?
Yes.
Okay. And today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However,
Right,
remember
you said,
that
excuse me, you said we have no witnesses. I did write on my first notice that Edward Vaughn was a witness because he was I got him the job where we work, and he was working with me along with another person. So I said on the first notice that they had his phone number because we both report to the same parole office, and I put him down as my witness.
Okay, one moment. So would you like him, what would be the purpose for his testimony?
To verify that what we were doing that day is distributing pamphlets, because we both work for Full Citizens Coalition, and I went to every public library in New Haven and every halfway house. I had just left. I went to Project Moore as well to drop off the pamphlets on 830 Grand Avenue, and Walter Brooks, a halfway house I went, which I discharged from originally. And then when I went to Sierra, he was in the car along with another resident, a resident of the halfway house of Sierra, and another co-worker. So I had two co-workers in my vehicle when I went into the building that could verify that we were only there dropping off, because we do reentry now at my organization, and we have pamphlets for the clients there in case they want to call us for resume, job training, and things of that nature.
Okay,
So I
that
wanted
would
him
be
to attest to that.
okay. And you do not have his phone number?
No, that's why I put on the paper that Officer Ruiz, because she's his parole officer as well. She knows his cell phone number. All I know is because of the technology now is we don't memorize numbers no more. We just see names. So I don't recall his number.
So I'm gonna just take a quick recess before I move forward, because so today you still like him as a witness today for this purposes of this hearing?
Just to attest to the job duties that we had at that day, because that was the reason I was there.
Okay, so I'm gonna just take a quick recess, okay?
All right.
Okay, Mr. Riles, we are back on record. So I just want to let you know that I did hear what you said today. I am taking it into consideration regarding your request for the witness. However, I'm not going to accept the witness for the following reason. Because your witness is regarding charge 1, obedience to the law, as to why you were at the halfway house, correct?
Yes.
Regarding charge 1, obedience to the law, on January 17th, 2025, a judge of the state of Connecticut Superior Court determined that there is probable cause to believe you committed the following offenses: criminal trespass first, stalking third, and breach of peace second. Therefore, I cannot revisit this finding. So regarding today, I was only going to take your testimony regarding charge 2, which is search, and charge 3, no alcohol, because a judge already established probable cause for charge 1. So testimony today will not be considered for charge 1 because probable cause was already established on January 17th by a judge.
So, this is why I didn't get an attorney, and this is why I'm doing this myself, because I have a $25,000 bond for this probable cause. There was no restraining order. There was no parole condition that I signed that said I can't be there. The last time the so-called victim, since they want to call her a victim, I'm gonna acknowledge that. The so-called victim saw me was 26 months ago when she got me arrested for threatening to inform.
Mr. Riles, what I'm trying to say is regarding charge 1, we can't revisit this finding. So your testimony, as well as your witness you wanted to provide, the probable cause was already established. So regards to even your testimony today, it's already established. So we're not going to revisit that finding. So in terms of revocation, if we go the revocation route, absolutely, at that time it would be taken into consideration. But in terms of for the probable cause today, the preliminary hearing, testimony is not being taken into consideration.
Okay.
Because probable cause was already established for that one charge. But regarding charge 2, search, and regarding charge 3, no consumption of alcohol, you can absolutely testify to that today.
Okay.
Would you like to testify to those 2 charges?
Yes, ma'am.
Okay, it's your time to do so.
I had a report date of January the 16th. That day when I went to Sierra, one of the coworkers was called by one of the staff members from Sierra about my appearance there, and he suggested I don't go back because they were trying to lock me up. So this was Monday the 13th. Thursday the 16th, that was my scheduled report date. So I'm thinking that because of the situation, the misunderstanding at Sierra, that they were going to book me or remand me anyway. So that Wednesday night, I had a final good meal at a restaurant with a girl, and I had wine with my steak, New York steak to be exact. And that's because I thought Thursday they was going to remand me for this misunderstanding. However, come Thursday, I was only given a misconduct ticket that I signed for going to Sierra, even though I didn't understand why I was getting a misconduct, because I was not legally prohibited at that time to not be in that building for the scope of my job duties. I could see if it was a trespass or I had no business there or purpose there, that's one thing, but there was no restriction preventing me from going in that building or even around that person. However, I signed a misconduct because I didn't think, I thought I was going to get remanded because, normally they don't care. They just remand you and that's that. So that's why the alcohol was in my person, because I thought it was, I'm Muslim. I don't even drink. I just had wine that Wednesday night. But the search and seizure, that I was already in custody. As soon as I went through the metal detector, they tricked me, made it. I didn't even think I thought I was good because the day before I just got a misconduct. That seems to disappear from the evidence that they presented because I signed that. That was my initial punishment, and the punishment was frequent report date. Like I would have to report weekly, even though I've been doing extremely well, which I kind of argue because it didn't make sense. But then again, they do what they want. So when I went across the threshold, I was pounced on. They put me against the wall, cuffed me, went in my pockets, went in my back pockets, my side pockets, my hoodie. I had gave my leather coat to P.O. Ruiz prior to even entrance because I didn't want to go through the metal detector holding that, so she carried that. So once they put the cuffs on, checked all of my pockets and stuff like that, the state police officer came and read me my rights. And when I heard my rights, I went crazy. I got in a panic attack because all this is a misunderstanding and some frivolous charges. So after voicing to them that my chest was hurting, they wanted me to sit in a chair. I said it would be better if I lay down. They wanted to go on my sneakers. I said, you can go on my sneakers. I'm not stopping you. I'm cuffed. I can't stop you. I can't stop you from doing anything you want to do to me, including bringing me to jail. So I guess they got mad and threw that in late because the original charge was just the obedience of the law charge, which is charge 1. That's the first paperwork I got when I got in Whaley Avenue. They didn't have that issue about me not letting them search my sneakers. I can't prevent them from searching my sneakers, Ms. Saunders, if I'm in their custody, cuffed up. I wasn't going to kick them. I wasn't wilding and being physically resistant. I just laid. I told them, put me down on the ground, my chest hurting. I'd rather be civically disobedient right now until the EMTs come. They came, and that was that. So originally that charge wasn't there, but I could see now that Harrison didn't want to throw it, whatever at the ceiling and whatever sticks. All I want today, the reason I didn't take a lawyer, Ms. Saunders, is because I'm not trying to make a sophisticated argument to you. This is about the truth. You just told me I can't even argue charge 1, which is blowing my mind that I can't. Because I'm not copping out to those charges. I told the judge that I want a speedy trial. I'm representing myself. I want to challenge my accuser because this is all stems from my first conviction with this woman of threatening too, which I only threatened to inform her staff that she was sleeping with clients. I was messing with a staff member in that facility. So because I was messing with a case manager, I knew who everyone was messing with. So once I stopped messing with that case manager, Ivy Collins, I still knew what's going on in the facility. Now, when she was trying to arrest me, I told her, if you jam me up for this frivolousness, I'm reporting you to your staff about who you're sleeping with. That was my threat. My threat was never physical, as you read in the exhibits from Connection, her incident report. You trying to jam me up and send me to jail? I could jam you up too because I know stuff.
Mr. Riles, sticking to charges 2 and 3.
Okay. All right. So, but I'm only saying this to segue into why I need to be free while I'm fighting this case. Because 1, my job, I'm the lead organizer of the state for Full Citizens Coalition, which is a Connecticut-based action group focused on undoing the unjust harm caused by felony disenfranchisement and ensuring that all citizens are respected as full citizens. That's our mission statement. I'm in charge of maybe 3 or 4 guys. We have an office in Hartford and an office in New Haven. I'm in the New Haven office on 178 Temple Street. Now, the DNR, which I feel is not warranted because of the frivolousness of these charges, is preventing me from 1, doing my job. 2, I have a vehicle out there that's parked. I don't even know how long it could be parked or where it's at. I own it. It's registered. It's insured. I have my license. I was currently living in a parole house, which is like an apartment efficiency where you're not monitored. You have a key, bathroom, kitchen. That person loves me who runs the house, Roger Hines. He's holding my stuff as far as my clothing and all my property that was in the apartment. My bond is $25,000. I could have made bond the day I got arrested because that day I was picking up a check for like $1,800. Plus my job is waiting to bond me out as we speak because I have work to do. And this is the misunderstanding, which is sad that I can't argue that with you, but I get it. The judge has supremacy over the decision makings for probable cause according to your system of adjudication. I get it. I just want, because of the nature of these charges, and it's not you. I'm pretty sure, even though I can't argue charge one, you've read. You're familiar with charge one and the background involving charge one. I never threatened her physically in the beginning. So for her to exaggerate any type of physical threat
Mr.
by
Riles,
me,
Mr. Riles,
I'm going to get into charge one. I'm sorry, but I'm pretty sure you've deduced that it was a misunderstanding. And right now, they put a protective order on me, which I didn't even challenge. I didn't even show up to court because I don't care. There's a protective order with me and Miss Broadbell for I got to stay 100 yards away from her. What else they did?
Okay, so regarding search and alcohol, regarding search, you keep going back to the number one, staying away from number one. We can't argue it. All right. So charge 2 and charge 3. If there's nothing further you have to say regarding charge 2 and 3, I could go into my findings. But if you're going to keep going back to charge 1, you can't do that because, like, again, the judge already established probable cause. But again, for if we go the revocation route, you can 100% bring all of these arguments to the revocation process if we go that route. Because again, for probable cause purposes, it's already been established. Okay.
Okay. So, am I allowed to argue for why the DNR should be lifted, and I can make bond and go back to my apartment and go back to my job and fight this case, which eventually will be thrown out before I pick a jury?
Only regarding charges 2 and 3, search and alcohol, and the severity of these 2 charges.
Got you. All right. Yeah. So I go through the search and seizure. They've always had authority to search my person, my car, and my apartment. They always have, and I've never given them an issue about it. Every time I go into parole for a meeting or when I'm scheduled to meet with my parole officer, I go through the metal detector. I take everything out. It's never been an issue with that. I understand they was upset with me because I was upset about these charges, and they're just throwing whatever they can throw. The alcohol, I told you, it was the night before. I don't drink. I'm Muslim. I think I had 2 dirty urines for alcohol in the whole 3 years I've been home. And that other one was because I didn't have any marijuana and I had a nip. I don't drink. And I've taken countless urines at the Project Moore house, Roger Emerson house apartment that I stay in. We have to take urines whenever they want there, just because we're there. So I take urines with Parole when I go see them every month, and I take whatever subjective urines Roger want to do with us. I follow all curfew. I've never brought in any females because we can't have company. I follow all rules there. He can attest to my behavior at that place. That's regarding the alcohol. The search and seizure, again, that I just think they just throwing whatever they could throw because that's not even a big deal. When I went to Welly Avenue, they took my sneakers. They were Jordans, and we can't even wear them in jail, and I had them sent to my job. I just want to be able. I'm 48 years old. I've been incarcerated for the last 17 years. I've spent 17 years in prison. If you add up the 15 I did and the times they bringing me back for these frivolous things with these cases, because as you can see, my criminal history has definitely changed because I went from drug charges, gun possession, federal cases, bank robbery, to miscellaneous charges like misdemeanors. And the other ones have gotten annihilated. My infraction got annihilated at the last halfway house, which they didn't even put in the evidence that the person took my charger. And I was being discharged to the Roger Emerson house, which is the parole house, the apartment I live in, the following day. So the person that I was living with took my charger and wouldn't give it back. Got aggressive with me. None of that's put in there because it's always designed to make me look like the bad guy, Miss Saunders. I've been out a total of 1 year. If you add the time I've spent on my own in the last 17 years. I'm not a threat to society. I don't tote guns. I don't gangbang. In fact, my job, we go against community violence. We work with community violent prevention on Aspen Street off of Dixwell. I'm in the city doing things for the community because that I feel like I've done nothing to the disenfranchised population of my community my whole life. I've added to that property devaluing of our society. Now I finally got a job to give back, and And I'm doing that, and I love my job. I'm getting $22 an hour. I saved $3,000 at the Roger Emerson house to put a security deposit on my own apartment when that time was up. I don't feel like I'm willing to go on a bracelet if I have to for a certain amount of time. I just want, my company is ready to bond me out. I didn't understand why the DNR was given to me for such charges like this when it's not a I'm not a threat to that building. I'm not a threat to that person. I haven't been a threat to anybody. Everyone wants to try to make me, Miss Saunders, out to be this violent person because I speak up for myself, because I believe in my own intelligence, because I'm not a slave to the state and I have to behave a certain way to where I was appalled that they even gave you the exhibit about parole when they came to see me in 2019 about parole. I think it's called Decision something. Right, all that was just to misnomer me in your eyes and put some type of cloud in your eyes so that you could say, oh, don't give this guy a chance. He's a piece of shit. I'm saying to you, Miss Saunders, I got an apartment still waiting for me from a guy who runs the apartment that can back me and attest to my behavior at that apartment, that I'm one of the best residents there. I have a job. If I could, you can call my boss right now. They'll pay for my bond. And I can fight this case on the street, which is, I feel, because of the severity of these charges are extremely minimal. And I don't have a history of going on the run. Like I said, I was told to report on Friday, even though Thursday on the 16th, they gave me a misconduct and the situation was over. But apparently the judge, during a 5-day span from January 13th all the way to the 17th, decided probable cause. I feel as though because I'm not a threat to nobody out there, the protective order's already, I didn't challenge it because it's never been an issue about wanting to see her or be around her. The parole condition can be added to stay out away from that building. I probably won't even drive down Howell Street anymore. That because of those precautionary measures that were set up, which if I do violate, which would make a felony, as far as it won't be most misdemeanors if I violate the protective order or if I violate the condition. So since these conditions are in place as we speak, and the frivolousness of the charges, which is a misunderstanding, which I can't argue, the alcohol has never been an issue with me. I don't use harsh drugs. I only smoke marijuana. And I had red wine the previous night on Wednesday because I thought I was going to get remanded Thursday for what I was hearing about the incident at Sierra. I didn't get remanded. I got remanded the next day. I reported knowing that I figured that that's why they called me in, because it's back-to-back days. I didn't run. I didn't hide. I was expecting them to come to the Roger house and get me. I drove there. I left my car right outside the Grand Avenue Parole state place. No, they didn't care about that. And I just wanted, if it's possible, to be able to go home, make bond, go back to work, doing what I was doing, and fight this case and get it probably eventually nollied or whatever.
Mr. Riles, I just have one question for you. When you were asked for the search, where were you? Were you still at the halfway house?
No, I was in the parole building on Grand Avenue.
You were in the parole office?
With my back face against the wall and cuffed like this behind my back with an officer here and an officer here and a state trooper reading me my rights. After he read me my rights and I heard the charges, which was stalking third and all that, I had a panic attack, which I do have a medical condition because I was in Northern for 12 years, which is solitary confinement. I didn't get out of that building until my lawsuit helped me get out because they were holding me without justification, because I've never been a physically threatening prisoner. Like, I have a bunch of tickets because I argue my case, or I practice civil disobedience. If I'm going to SEG unjustly, carry me to SEG. I'm not walking. If I do something like get in a fight or say something crazy to somebody, I gladly walk to SEG. But whenever they use their authority in an abusive way, my only form of protest was civil disobedience, which I even did at the Grand Avenue parole office, and the police and the ambulance had to come because I was having chest pains. But I only did that because I can't do anything else. So it's like when the charges was read to me, Mr. Saunders, I got hypertension. I take medication right now, Seroquel. I'm back on that because I can't sleep without it in jail. I'm 48 years old. I'll be 49 in July. I need this job. I've been doing this job since July. I've 6 months. I went from part-time to full-time. I had $3,000 saved with Roger Emerson House. I got a bank account in New Haven Savings Bank on Whaley Avenue. I had things in motion. I helping my mother out. I have a daughter that I'm just finally getting to know who's in DC. I can't afford to just be sitting in jail for charges like this when I'm not a threat to society, when I'm not showing any criminal activity. This is just a misunderstanding that unfortunately, I can't even argue it with you today because a judge supersedes whatever power you have. So all I'm saying, if you do have the power to consider releasing me so that I can make bond and even wear a bracelet for a time period, I will do whatever y'all want me to do. I just want to go back to work and save money and continue doing what I was doing. That's all I want to do. I am not a threat to no one, Ms. Saunders.
Thank you, Mr. Riles. I'm going to take a moment before I announce my findings, okay? Okay, Mr. Riles, we are back on record. So I just want to, before I go into my findings, I just want to make it known that I did hear your argument regarding it not being serious enough, especially in regards to the do not release and you being on the $25,000 bond. I heard that when you said your job can make the bond for you. So, and I just want to make sure that I let you know I did hear everything you said today. So with that said, I'm going to go into my findings. Regarding charge 1, as I said, probable cause was already established. I'm just doing this for the record. So no testimony was taken into consideration for charge 1 because probable cause was already established by a judge of the state of Connecticut Superior Court. Charge 2, search. I make a finding of probable cause based on your testimony today, as well as state's exhibits A and E. On charge 3, no consumption of alcoholic beverages. I make a finding of probable cause based on your testimony today, as well as state's exhibits A, E, and K. I find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. So this does conclude the preliminary hearing.
This is bullshit. Them are not serious charges of violation because they couldn't go. When I was laying on the ground, they could have went in my sneakers. What do you mean? They could have went in my sneakers when I was laying on the floor. It's not about that. You know that. I wasn't kicking. And they had ample opportunity to go in my sneakers. I sat in there for damn near 45 minutes waiting, being checked by medical and all of that. That's 2. And then 2, alcohol. That's not even nobody gets violated on 1 alcohol consumption ticket. Nobody gets violated on that when you're outside. So why is that violation now? Why is that a violation now?
Your preliminary hearing.
No, that's bullshit. That's bullshit. You're doing that for Miss Harris. All y'all work together. Y'all don't do nothing for us. Y'all don't do nothing for our people. All y'all do is want to keep us in jail because y'all some bunch of house niggas. That's what y'all are. Frankly, that's all y'all are. Y'all like seeing men, your own men suffer. Look, you probably a lesbian yourself, ain't you? You don't like men either. All y'all like that. All y'all don't give a fuck about our lives. I'm sitting in jail for some alcohol and because they couldn't search my fucking shoes. Are you kidding me? Are you kidding me? I got frivolous charges of $25,000 bond, which is nothing. Y'all all pieces of shit. Take that, bitch. House.
Thank you so much for the wait. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Ernesto Hernandez, 417767. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in McDougall Correctional Institution. Please state your full name and DOC MA number for the record.
Ernesto Hernandez, 417767. Good morning.
Good morning. This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to oppose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Hernandez, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charge that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No. I got a suggestion. Can you speak slow? Because my English is, so I can't understand.
Do you want an interpreter? I can speak slower, but do you want an interpreter?
I mean, if you can get one, yeah.
Okay, do you want me to repeat what I've already said, or I can get the interpreter right now, but do you want me to start over with the interpreter?
Yes, please.
Okay, give me one moment.
All right, thank you. I'm sorry.
Mr. Hernandez, give us a few more minutes and we'll get started with the interpreter.
All right, thank you.
No
I
problem.
apologize.
No problem at all. I'm going to start over.
Ella va a empezar nuevamente.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Ernesto Hernandez, 417767. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and McDougall Correctional Institution. Before she translates, I have to sign her. I have to swear in. Good morning, Liza Revere. Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to the best of your abilities, so help you God, or upon penalty of perjury? Thank you.
Buenos días, soy la oficial Saunders, examinadora de audiencias para la Junta de Indultos y Libertad Condicional de Connecticut. Esta es una audiencia de revocación preferente a Ernesto Hernández, número 417767. Hoy es martes 18 de febrero del 2025 y esta audiencia se está llevando a cabo a través de video en la Junta de Indultos y Libertad Condicional, localidad central, y el Centro Institucional de McDougall.
Please state your full name and DOC-MA number for the record.
Por favor, decir su nombre y número de DOC de confinado para el registro.
Ernesto Luis Hernández Rodríguez, 417767.
This is a public hearing. Public access to this hearing is available video live stream.
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction.
Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hechos en cuanto a cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia. Es decir, la mejor evidencia o más pesada debe establecer que más probable que no la alegación es cierta. Si no encuentro que haya una preponderancia de evidencia que respalde una violación de una o más de las condiciones de su libertad condicional, restableceré su libertad condicional, lo que significa liberarlo, ponerlo nuevamente bajo supervisión. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Si recomiendo la revocación, haré una recomendación en cuanto a una sanción apropiada. Mi recomendación se dará a un panel para una decisión final. Si el panel desea imponer una sanción más allá de mi recomendación, se proporcionará una audiencia suplementaria para justificar un confinamiento adicional.
My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. Oh, you said that? Oh, the testimony of today's hearing will be taken under oath. Mr. Hernandez, please raise your right hand.
El testimonio del día de hoy será tomado bajo juramento. Mr. Hernández, favor levantar su mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia provista en este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You would have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Ahora le voy a hablar acerca del procedimiento de la audiencia. Primero voy a leer sus derechos. Luego revisaré los cargos de la violación de libertad condicional que su oficial de supervisión ha presentado en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. Usted y el Estado usted tendrá la oportunidad de presentar testimonio relevante. Luego de considerar la evidencia presentada, anunciaré mis hallazgos. Si encuentro que usted ha violado una o más de las condiciones de su libertad condicional, usted tendrá la oportunidad de hablar acerca de sus antecedentes e historial. ¿Tiene alguna pregunta antes de comenzar?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Usted tiene derechos importantes en esta audiencia. Usted tiene el derecho a ser representado por un abogado. Si usted no puede pagar un abogado, puede calificar para un abogado asignado que lo represente. ¿Tiene la intención de usted buscar un abogado o desea proceder sin abogado?
Deseo proceder sin abogado.
I would like to go forward without a lawyer.
You have the right to receive written notice of charges violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Usted tiene derecho a recibir una notificación por escrito de los cargos de la violación. Tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Usted tiene derecho a presentar pruebas en apoyo a su caso. En esta audiencia, usted tiene el derecho de llamar e interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Entiende usted sus derechos?
Sí. Yes, ma'am.
We now review the charges of the state Europol officers bringing against you and the information underlying each charge.
Ahora estaremos revisando los cargos que su oficial de supervisión está presentando en su contra y la información subyacente a cada cargo.
On charge 1, absconder, on February 25th, 2023, you signed out of Central Ave Halfway House for work at Whole Foods located at 400 East Johnson Avenue in Chester, Connecticut, and you were expected to return at 12 a.m. Once you failed to return to your only approved PCS residence, staff attempted to contact you on your cell phone. However, the number was disconnected. You were not admitted to any local hospitals or police departments. You failed to contact your parole officer and your whereabouts remain unknown in the community. Charge 2, obedience to the law. On October 30th, 2023, you were involved in an altercation in Waterbury. You attacked an elderly couple at an ATM. You were subsequently arrested and charged with robbery third, assault third, with an elderly victim, and interfering and resisting.
En el cargo número 1, fuga. El 25 de febrero del 2023, usted salió del Central Avenue Halfway House a trabajar en Whole Foods en el 400 de la Johnson Avenue en Chester, Connecticut, y estaba supuesto a regresar a las 12 de la medianoche. Usted falló a regresar a su única residencia aprobada por PCS. Empleados intentaron contactarlo a su celular, sin embargo, su número estaba desconectado. Usted no había sido admitido a ningún hospital o departamento de la policía. Usted falló a contactar a su oficial de supervisión y su paradero se encontraba desconocido en la comunidad. En el cargo número 2, obediencia a la ley, el 30 de octubre del 2023, usted estuvo envuelto en un altercado en Waterbury, donde usted atacó a una pareja mayor de edad en una ATM. Usted subsecuentemente fue arrestado y acusado con robo en tercer grado, agresión en tercer grado a víctima mayor e interferencia, resistencia.
The state has filed the following exhibits. Exhibit A, PCS conditions. Exhibit B, halfway house agreement. Exhibit C, parole violation notice. Exhibit D, Central Ave incident report. Exhibit E, Central discharge report. Exhibit F, remand to custody order. Exhibit G, parolee rights. And Exhibit H, Waterbury incident report.
El Estado ha presentado la siguiente evidencia en su caso. Exhibición A, condiciones de PCS. Exhibición B, acuerdo de Halfway House. Exhibición C, aviso de violación a libertad condicional. Exhibición D, reporte de incidente de Central Avenue. Exhibición E, reporte de salida Exhibición F, orden de regreso a custodia. Exhibición G, derecho de persona en libertad condicional. Exhibición H, reporte de incidente de Waterbury.
The state has filed an addendum to the PPR, which states on September 24th, 2024, Mr. Hernandez was sentenced to 5 years jail, execution suspended after 1 year jail, followed by 3 years probation for robbery third. Mr. Hernandez was also convicted of interfering with officer and resisting and was sentenced to unconditional discharge. The charge assault third to an elderly victim was nollied under docket ending 629. Mr. Hernandez, did you receive the parole violation report and the other documents that were just marked for identification purposes? You didn't receive
No.
any evidence.
No,
Okay.
never. They told me everything was running concurrent and they didn't. Yo envié una moción a la corte porque ellos me habían dicho que todo iba a correr concurrente y no lo hicieron. Me dieron una fecha de salida para salir, tampoco lo hicieron. Nunca presentaron videos de las evidencias porque yo no me resistí nunca. A mí me brincaron un montón de gente encima que no tenían que ver con oficiales de la policía.
Okay. So I submitted a motion to the court. It was supposed to run concurrent to what I'm doing right now. There was no evidence of what happened. There was a lot of people that jumped me. Y que las personas le brincaron
Que
encima.
eran oficiales de policía que en el reporte que dice. En el
So
reporte
what-
dice.
Mr. Hernandez, what I was referring to, so you're going to have an opportunity to speak regarding the charge. What I'm asking regarding there's a packet that you should have received when you first came into custody. I think you've been in custody since 2023. So back in October 2023, you didn't receive any documentation regarding these allegations.
En octubre del 2023, usted llegó a recibir un documento por correo con los documentos de la violación a libertad condicional, un paquete por correo que tenía ciertos documentos, los que estamos leyendo en el día de hoy, y evidencia.
Yo recibí un papel que tenía el absconder, entonces el caso nuevo que era assault. That was it.
Paper that had the absconder and the assault charge.
Okay, so you received the documentations from Parole stating why you were brought back into custody.
Usted
Yes,
recibió los
yes, ma'am.
documentos de libertad
Okay.
condicional. Okay.
And so you had time to review all of the evidence and the charges against you at that time.
¿Usted tuvo la oportunidad de revisar estos papeles en ese momento?
Cuando me lo sirvieron, yo les dije a ellos que lo necesitaban en español. Yo vine en el 2014 a Estados Unidos, yo no sé mucho inglés, estoy apenas aprendiendo todavía y nunca me los trajeron.
When I received those papers, I told them that I needed the paperwork in Spanish because I've been here since 2014 and I do not understand it.
Okay, so do you want to continue this hearing so we can have everything translated to you in Spanish?
¿Usted desea continuar este caso para que esto se pueda traducir en el idioma de español para usted?
Yes, ma'am.
Okay, let me just take a quick recess before I accept the continuance, okay?
Deje tomar
Sí.
antes de aceptar esta continuación, ¿ok?
Okay, Mr. Hernandez, we are now back on record. I just have a few questions for you. When you went to your criminal proceedings, your court hearing regarding the robbery charge, did you have a Spanish interpreter at that time?
Mr. Hernández, cuando usted fue a su audiencia de corte para sus procedimientos de corte, ¿usted tuvo un intérprete en español en ese momento?
I think the first time
Okay, so do you understand what took place at court, your conviction?
¿Usted entiende lo que sucedió en la corte? ¿Cuál fue su convicción?
yes, ma'am.
Okay, so based off of that, so you understood why you were charged with absconder, which we read here to you today, and you also understood that you were convicted of a new crime. So your request for a continuance, I can grant that here today, but I can't guarantee that any of the documents submitted in the parole package is going to be translated in Spanish. I just want to make sure you're aware of that. So if you want to still continue, we can, but just understand that, one, you're aware of your new conviction. You understand what occurred at court. We also read you your charges for absconder today. So I just want to make sure that you still want to move forward with the continuance.
Mr. Hernández, ¿usted entiende cuál fue el cargo de fuga por lo que usted está aquí en el día de hoy, además del cargo que usted fue convicto, que fue un nuevo crimen? También leímos los cargos en el día de hoy en español. Yo puedo continuar este caso. Lo que quiero es que usted entienda que yo no le puedo asegurar que todos estos documentos puedan ser traducidos al español.
All right.
So you still want to continue this hearing?
Yes, ma'am.
Okay. For what's the purpose of the continuance then? If you understand that you're being charged with an absconder, which you understand that charge, and you also understand your new conviction, I just want to make sure, what am I granting a continuance for?
Si usted entiende lo que sucedió, usted entiende el cargo de fuga, usted entiende por lo cual usted está convicto, ese nuevo cargo, ese nuevo crimen, yo quiero estar segura por qué es que estamos continuando este caso en el día de hoy, si usted entiende esto.
Sorry, and also you're being made aware that these documents, I can't guarantee that any of these documents are going to be translated in Spanish for you. So with all of that taking into consideration on your end, what would be the continuance for?
Además de que le estamos diciendo que no podemos garantizar que todos estos documentos puedan ser traducidos al español, ¿cuál sería entonces el motivo que usted quisiera continuar esta audiencia?
Primero, no sé por qué estoy aquí. So, ustedes fueron los que me llamaron, like, I don't know.
First of all, I do not know why I am here. You were the ones who called me.
A mí nunca a mí nadie, el Parol nunca vino a verme. La sentencia ilegal que hicieron fue un desastre. me dieron 2 cortes distintas, Bridgeport en Woodbury, y se supone que los casos los corrieran juntos y los corrieron totalmente separados. Por eso hice la moción. El Parol nunca me ha venido a ver nada.
First of all, the sentence was a disaster. I had court in Bridgeport, then I have court in Waterbury, 2 different places. Que se supone que fuera.
It was supposed to renash a concurrent, and they never did. And Parole never came and see me. Nothing. Like, I was supposed to go home. I was supposed to be home. Nothing.
Mr. Hernandez, this is Parole Supervisor Muniz. I'm here on the record. I heard what's going on in regards to this hearing. Yo estoy aquí, soy supervisora Muniz, estoy escuchando lo que sucedió en esta audiencia. What I'm here to tell you today, lo que estoy aquí para decirle a usted hoy, you want to continue, quiere continuar esta audiencia, and you said that you don't know why you're even here today, that we're calling you down. Que usted dice que usted no sabe ni por qué está aquí hoy, que por qué lo están llamando. We could grant you a continuance, te podemos otorgar una continuación, no hay ningún problema por eso, there's no problem for that. However, in regards to the documentation being translated into Spanish, that's something that I don't know if we could get for you, but we could continue it and ask for community services for that to be done, because that is their evidence. So te podemos continuar esta audiencia hoy, pero tenemos que preguntarle al libertad, el parol tuyo.
Libertad condicional.
A ellos, lo que te supervisaron, si ellos pueden transferir esos documentos en español o no. Eso es lo único que podemos hacer por usted hoy. That's the only thing we can do today, is continue this case and ask for community services if they could translate those documents and come. You could get an attorney if you want appointed to you and ask for one. It's up to you what you want to do today. Es lo que usted quiera decidir hoy, que es lo que usted quiere hacer hoy.
No entiendo la continuación hacia qué. No.
So you don't understand the continuation. I'm going to speak just in English so that you can translate that, so it doesn't get confusing. The continuance is up to you if you want a continuance. Do you say that?
La audiencia se puede continuar, pero eso es a discreción suya. Si usted desea que esta audiencia se continúe y no siga, no proceda en el día de hoy.
And he says that he doesn't understand why he's here today. The parole officer Saunders explained to him why he's here today. He was on parole. And
I violate.
Usted mencionó que usted no entiende la razón por la que usted está aquí en el día de hoy. La oficial examinadora Saunders le explicó en el día de hoy la razón por la que usted está en el día de hoy.
Could we start over the hearing to explain to him why he's here today? Podemos empezar la audiencia otra vez si quiere para explicarle por qué está aquí hoy.
Would you like that?
¿Quiere que se comience la audiencia nuevamente?
Do you want an attorney to be appointed to you, possibly, if he's eligible, to explain to him the hearing and the process? We could also request that as well.
Usted también puede solicitar que se le asigne un abogado. Usted también puede solicitar esto.
So what's gonna happen? What's going on? Like,
Okay, Mr. Hernandez, you're here because you were on parole. Let's go back to the beginning. You were on parole. You were discharged to parole originally in February 2023. Okay? You absconded from parole. Per the allegations, you absconded from parole. Then you were remanded once you were arrested in October 2023.
Translate that, please.
with a new case.
Right.
Do you need that translated or not?
En algunas cosas, yo no entiendo mucho inglés. Yo llevo
Okay,
aquí desde el
so-
2014. Solamente
Okay,
11
so-
años. Todavía estoy
Right,
aprendiendo inglés.
if you want a translator, we're gonna have a translator. You have to wait for the translator to translate everything for you to answer. Okay?
All right.
Because I want to make sure that you understand everything. Can you please translate that?
Mr. Hernández, usted salió bajo supervisión de libertad condicional en febrero del 2023. Usted se fugó de su supervisión, básicamente tuvo un cargo de fuga bajo su supervisión de libertad condicional. Luego usted fue regresado a custodia por el arresto que usted recibió en octubre del 2023.
Okay. So when you were remanded in October 2023, you were pending charges. It appears that you've gone through the court process.
Cuando usted fue regresado a custodia, usted todavía tenía cargos pendientes.
Okay. When you were remanded, PCS charged you for absconding and the pending charges.
Cuando usted fue regresado a custodia, libertad condicional básicamente lo regresó a custodia y lo acusó por el cargo de fuga y por los cargos que usted tenía pendientes del nuevo cargo.
Now that your charges have been disposed of, adjudicated, the court gave you a new sentence of 5 years jail, execution suspended after 1 year, 3 years probation for robbery third. Now that those charges are taken care of, we are here today because you were on parole. And you took care of the criminal part, but because you were on parole, you also have to be heard based off of violating for the alleged charges of absconder and new criminal charges.
Usted está aquí en el día de hoy porque ya usted fue a la corte, los cargos que usted tenía pendientes ya se fueron resueltos en la corte, ya usted no tiene más ningún cargo criminal pendiente. Usted recibió una sentencia de 5 años, ejecución suspendida después de servir 1 año de prisión y 3 años a seguir de probatoria. La razón por la que usted está aquí en el día de hoy es porque usted estaba en supervisión cuando esto sucedió, por lo tanto, usted tiene una audiencia pendiente por la violación en el cargo de fuga y por este cargo criminal que ya usted fue sentenciado.
My job today as a hearing examiner is to conduct a revocation hearing because you were on parole at the time.
And you still have parole running until when?
September 2025.
Yo soy la examinadora de audiencia y la razón por la que yo estoy en el día de hoy es para llevar a cabo su audiencia, ya que usted, cuando esto sucedió, usted estaba bajo supervisión de libertad condicional y todavía está bajo supervisión de libertad condicional hasta septiembre del 2025.
Do you have any questions about that thus far?
¿Tiene alguna pregunta en relación a esto hasta el momento?
No.
So today is a revocation hearing based off of the evidence that you received and that your parole officer submitted to us back in 2023 when you were brought back into custody. My job today is to make findings of fact based off of the available evidence and your testimony here today.
Usted está teniendo una audiencia de revocación en el día de hoy basado en la evidencia recibida por su oficial de supervisión atrás en el año 2023. Mi propósito en el día de hoy es para encontrar hallazgos de hecho y escuchar su testimonio en referencia a esa violación que sucedió.
Now, earlier I read you your rights. A part of your rights is that you have an opportunity and the right to be represented by an attorney, which you indicated that you wanted to proceed without an attorney.
Usted tiene derechos en esta audiencia, los cuales yo le leí al comienzo de la audiencia, donde usted tiene derecho a ser representado por un abogado si usted así lo desea. Usted mencionó que quería proceder sin un abogado en el día de hoy.
Now, if you wanted it, just so you're aware, if you wanted an attorney, they would represent you here today. Or if we continue it, if you want an attorney, we can always continue it and apply to see if you qualify for an attorney. And if you do, they would then represent you today if we continue it at your revocation hearing and speak on your behalf. They will set up a meeting with you to discuss this entire case.
Usted puede solicitar que se le dé consejería o un abogado para una audiencia. Tendríamos que continuar este caso. Si usted aplica y se le concede una representación legal, entonces la representación legal o el abogado se reuniría con usted y hablaría acerca de este caso y ellos entonces lo representarían a usted en una nueva audiencia cuando se continúe.
The question of a continuance came up when I asked you the question, if you received the evidence, if you received the parole violation charges. You said you received it, but you at that point asked for everything in Spanish, correct? That's what I understood.
La razón por la que usted mencionó que quería que se continuara este caso fue cuando yo le pregunté si usted recibió los documentos que habíamos mencionado en el registro. Usted dijo que sí, que los recibió, pero que usted quería que estos documentos fueran traducidos al español. ¿Es esto correcto?
Correcto.
So if you want to proceed, now again, the continuance does not have to happen. It's up to you. So to be clear, if you ask for a continuance, that means we will move this hearing to a later date and we will request for the parole community services to translate all of the documents in Spanish. Now, we cannot guarantee that will happen.
Nosotros podemos continuar este caso si usted así lo desea para una nueva fecha, sería una fecha más adelante. Tendríamos que solicitarle a servicios comunitarios de libertad condicional o sus oficiales de supervisión afuera en la comunidad que traduzcan estos documentos. Sin embargo, no podemos asegurarle que estos documentos vayan a ser traducidos.
Okay, go ahead. Yes.
So, ¿cuán importante sería una representación de un abogado y qué beneficios yo tendría?
How important it is for me to get counsel and what type of benefits will that give me?
That's up to you. That's up to you. I can't answer that because it's solely up to, it's your decision if you want to be represented. We can also continue the hearing if you wanted to speak to an attorney, see if you qualify for a court-appointed attorney. So it's up to you, solely up to you.
Yo no podría contestarle eso. Es a discreción suya. Si usted quiere que un abogado lo represente, para beneficio suyo, es a su discreción. Si usted desea continuar el caso para que entonces se le dé un abogado, asigne uno.
A mí me gustaría continuar para terminar esto lo más rápido que se pueda en salir de uno, salir del paso.
I would like to move forward to just get it over with.
Okay, so no attorney, and we're going to move forward with, we're going to just go forward. I'm going to continue with the hearing.
Entonces usted no va a solicitar un abogado. Voy a continuar con la audiencia en el día de hoy.
Okay. So today we have no witnesses.
En el día de hoy no tenemos testigos.
About 15 minutes ago, we read you the charges for absconder and obedience to the law. I also put on record your new conviction, okay? So you understand what you're sentenced to. You understand the charges against you, absconder and obedience to the law. It is now your opportunity to speak and respond to the violation charges against you. But remember, you may remain silent if you choose to do so. Do you wish to testify regarding the charges?
Ya anteriormente yo le leí los cargos por lo que está usted aquí en el día de hoy, el cargo de fuga, el cargo de obediencia a la ley, la nueva convicción que usted tuvo por este arresto. Entonces usted tendría la oportunidad ahora de hablar acerca o presentar algún testimonio en relación a este caso. Usted no puede permanecer en silencio si así lo desea, o puede testificar si usted desea en relación a este caso.
No tengo nada que decir.
I don't have anything to say.
Okay. So now what I'm going to do is I'm going to make my findings regarding charge 1, which is absconder, and charge 2, obedience to the law. Regarding charge 1, absconder, I make a finding based on state's exhibits A and D. On charge 2, obedience to the law, I make a finding based on Mr. Hernandez's conviction as well as state's exhibits A and H.
Ahora yo le voy a anunciar mi hallazgo. En el cargo número 1 de fuga, yo hago un hallazgo basado en las exhibiciones del Estado A y D. En el cargo número 2, obediencia a la ley, yo hago un hallazgo basado en la convicción de Mr. Hernández y también de la exhibición del Estado A y H.
So that concludes the fact-finding portion of this hearing. Before I make my recommendation regarding a sanction, you have an opportunity now to speak to your future plans, what you've done while you were in absconder status. What's your plan for the future? And if you want to discuss what you were doing while, in absconder status, it's up to you if you wish to make a statement.
Esto concluye la porción de investigación de hechos de esta audiencia. Antes de hacer mi recomendación, usted tiene la oportunidad de hablar acerca de sus antecedentes o historia o algún plan futuro que usted tenga o lo que usted estaba haciendo cuando estaba bajo supervisión de libertad condicional a discreción suya.
And when I say future plans, I mean employment. Where do you plan to live if your parole is reinstated?
Cuando hablo de planes futuros, me refiero, por ejemplo, a empleo. ¿Dónde usted tiene planeado vivir si llega a ser puesto bajo supervisión nuevamente?
Mis planes son, yo soy barbero y siempre he recortado retornar a una barbería o tener mi propio, you know, how you call like, establecimiento, my place, you know, my own place.
Go back to the barber shop or just have my own place, su propio negocio,
Yeah,
my own
Basic.
business.
Oh, like own your own barbershop business?
Su propio negocio de barbería,
básicamente, yeah.
basically, yes.
Okay, so your plan is to eventually open up your own barbershop business?
Sus planes es eventualmente poder abrir su negocio de barbería.
Okay, and
Yes,
upon parole reinstatement, where would you want to reside? Do you have a sponsor? Would you like to go to a halfway house placement?
Si usted es puesto nuevamente bajo supervisión, ¿cuáles son sus planes de residencia? ¿Usted tiene alguien que lo patrocine o necesita ubicación en halfway house?
Me gustaría retornar a un halfway house.
I would like to go back to a halfway house.
Okay, in what area?
¿En qué área?
Puede ser Waterbury, Hartford.
Could be Waterbury or Hartford.
Okay. Anything else you plan on doing in the community? So whether you become a barber or open up your barbershop, it sounds like being in that industry, the barbering industry is what you plan to do for employment and a halfway house placement. Anything else you plan on doing?
¿Algo más que usted planea hacer aparte de abrir su negocio de barbería, ir a un halfway house?
Soy sincero, yo tengo mi familia en Puerto Rico, yo no tengo a nadie aquí, no tengo absolutamente a nadie. Mi madre, mi padre, todo el mundo, mi mamá está a punto de morirse ya, tiene cáncer. Una de las razones por las que yo sigo, you know, me descarrilo, hago lo que hago, whatever, es porque tengo tantas cosas encima, ansiedad, depresión, yo lidio con tantas cosas diarias que just, I don't know what to do. Yo no sé qué más hacer, I don't. So, mis planes son, si puedo salir, ¿me entiendes? Sería un halfway house porque yo sé que ellos me dan ayuda. Sé que tengo más requisitos para poder moverme, echar para adelante, ¿me entiendes? Y no estar estoqueado en prisión, seguir back and forth.
One of the reasons I am going to be honest with you, I do not have anyone here. All my family is in Puerto Rico. I have my mom and my dad. They are down there. My mom, she is ill. She has cancer. And one of the reasons that I'm doing what I'm doing is because I have a lot of anxiety. I am dealing with a lot of things and I do not know what to do. If I am to be released, I would like to go to a halfway house because I think that would be a good placement for me where I can get help, the help that I need to keep moving forward.
Okay. Anything else, Mr. Hernandez?
Algo más, señor Hernandez.
Thank you. So what I'm going to do now, I'm going to take a moment. I'm going to take everything into consideration, what you just said, your new charges, your previous history. I'm taking everything into account. And then I'm going to make a recommendation regarding an appropriate sanction.
Yo lo que voy a hacer ahora, yo voy a tomar todo esto en consideración, los cargos, lo que usted ha hecho, el testimonio del día de hoy, y entonces haré una recomendación acerca de una sanción apropiada.
I recommend revoke and no new re-parole date, which is an approximate 1 year and 10-month sanction with the following conditions. No contact with victims VB and ZD. No contact with co-defendant Estefany Vasquez. Halfway house placement and mental health evaluation.
Yo recomiendo que su libertad condicional sea revocada y que no se le dé una nueva fecha de supervisión, lo cual sería a year and a half.
A year and 10 months.
1 año y 10 meses de sanción. Además, las siguientes condiciones: no contacto con la víctima VP y ZD. No contacto con el coacusado co-defendant. Estefany Vázquez. Ubicación halfway house y evaluación de salud mental.
My findings and recommendations will be given to a board. The board is going to take a look at your case on February 27th. Being that my recommendation is that you go to the end of your sentence, which is in September 24th, 2025. That's my recommendation for you to go to end of sentence. The board can agree with that decision, or they can lessen that decision. If they lessen that decision, or even if they agree, you're going to get everything in writing after February 27th, because that's when they're going to look at your case.
Mis hallazgos y recomendaciones van a ser presentados a la Junta lo cual yo estoy recomendando que llevarlo hasta el final de su sentencia, que es en septiembre 24 del 2025. Esto sería el 27 de febrero del 2025, la revisión de la Junta. La Junta puede disminuir su sanción, dejar mi sanción recomendada. Si ellos deciden, usted va a recibir todo esto por escrito, y si ellos si deciden imponer una sanción más larga o disminuir la sanción, usted va a recibir notificación por escrito de la decisión.
So that's it. The hearing is over. And so you'll receive everything else in writing within probably a week of after February 27th, okay? With the board's final decision.
Usted va a recibir todo por escrito. La revisión de la Junta es el 27 de febrero. Aproximadamente una semana después de esto, usted va a recibir todo por escrito de cuál fue la decisión de la Junta en esta revisión.
All right. Thank you, Mr. Hernandez.
Thank you. Have a nice day.
You too.
Hello.
I don't know what happened.
Hi.
Hi, okay.
Good morning. Thank you for waiting. Sorry we're late.
No,
We're gonna get
no
started in just
problem.
a few moments.
Okay,
Oh my God.
thank you.
It's more recent.
Good morning, Liza Rivera. Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to the best of your abilities to help you God or upon penalty of perjury?
I do.
Thank you. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Louis Ortiz, inmate number 389700. Today is Tuesday, February 18th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Bridgeport Correctional Center.
Buenos días, soy la oficial Saunders, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia de revocación referente a Luis Ortiz, número 389700. Hoy es martes 18 de febrero del 2025 y esta audiencia se está llevando a cabo a través de video en la Junta de Indultos y Libertad Condicional, localidad central y el Centro Correccional de Bridgeport.
Please state your full name and DOC inmate number for the record.
Por favor, decir su nombre y número de DOC para el registro.
Mi nombre es Luis Ortiz, mi número de presa es 389700.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is Parole Officer McCarty.
Esta es una audiencia pública, acceso público a esta audiencia está disponible vía transmisión en vivo. Presente esta mañana, esta tarde también está el oficial de libertad condicional McCarty.
Okay.
You can introduce yourself for the record.
Oh, good morning. For the record, Parole Officer McCarty from the Interstate Unit at the Board of Pardons and Paroles.
El oficial McCarty de la unidad interestatal de la Junta de Libertad Condicional de Connecticut.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction.
Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hechos en cuanto a cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia. Es decir, la mejor evidencia o más pesada debe establecer que, más probable que no, la alegación es cierta. Si no encuentro que hay una preponderancia de evidencia que respalde una violación de una o más de las condiciones de su libertad condicional, restableceré su libertad condicional, lo que significa liberarlo y ponerlo nuevamente bajo supervisión. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Si recomiendo la revocación, haré una recomendación en cuanto a una sanción apropiada.
My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement.
Mi recomendación se dará a un panel para una decisión final. Si el panel desea imponer una sanción más allá de mi recomendación, se proporcionará una audiencia suplementaria para justificar un confinamiento adicional.
The testimony at today's hearing will be taken under oath. Mr. Ortiz and P.O. McCarty, please raise your right hand.
El testimonio del día de hoy será tomado bajo juramento. Mr. Ortiz, favor levantar la mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you.
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia provista en relación a este caso será la verdad, toda la verdad y nada más que la verdad, que así lo olvide Dios o bajo penalidad de perjurio.
Sí.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bringing against you. Then I will review and identify exhibits filed for the record. You, as well as the state, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you and the state will both have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Primero voy a leer sus derechos, luego revisaré los cargos de la violación de libertad condicional que el Estado, su oficial de supervisión, está presentando en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. Usted y el Estado tendrán la oportunidad de presentar testimonio relevante sujeto a contrainterrogatorio. Luego de considerar la evidencia presentada, anunciaré mis hallazgos. Si encuentro que usted ha violado una o más de las condiciones de su libertad condicional, usted tendrá la oportunidad de hablar acerca de sus antecedentes e historial. ¿Tiene alguna pregunta antes de comenzar?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Usted tiene derechos importantes en esta audiencia. Usted tiene derecho a ser representado por un abogado. Si usted no puede pagar un abogado, puede calificar para un abogado designado si así lo desea. ¿Tiene intención de buscar un abogado para esta audiencia o desea proceder sin un abogado?
Sin abogado.
No counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Usted tiene derecho a recibir una notificación por escrito de los cargos de la violación. Usted tiene derecho de revisar la evidencia en su contra antes de esta audiencia. Usted tiene derecho a presentar pruebas en apoyo a su caso. En esta audiencia usted tiene el derecho de llamar a interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Entiende usted estos derechos?
Sí.
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. P.O. McCarty, starting with charge 1, absconder.
Ahora estaremos revisando los cargos que el Estado, su oficial de supervisión, está presentando en su contra y la información a cada cargo.
Officer Saunders, I did just want to add for the record that I will read all of the charges at your request. I will only be testifying with regard to the absconder charge, as that was the only charge incurred while he was under the interstate unit for supervision. The additional charges that were added to this violation were imposed by the fugitive unit, so I cannot testify regarding those.
Thank you.
Yo quería mencionar para el registro que solamente voy a estar leyendo los cargos en el día de hoy, específicamente el que está relacionado a fuga, ya que este fue el periodo donde estaba en la unidad interestatal. Los demás cargos fueron presentados por la unidad de fugitivos.
See? Yes. Okay. Charge number 1 is the condition violated is an absconder violation details. You last had contact with Delaware probation on May 2nd, 2024 at the time of an office visit. At that time, you were residing with your mother and stepfather in Bridgeville, Delaware. You were directed to return for another office visit on 6/20/24. You had contact with Bridgeville police on 5/9/24 due to a domestic dispute. On 6/3/24, your mother reported with an interpreter to the probation office and advised that she contacted police again due to your threats. Warrants were issued on May 29th, 2024 and May 30th of 2024 for terroristic threatening. On June 12th, 2024, a follow-up call was made to your mother. At that time, she advised that you were no longer living at her address and your exact whereabouts were unknown. She believed you to be in the Georgetown area, but was unable to provide any further details. A home visit was conducted on July 1st, 2024 at the last reported residence, but Delaware was unable to make contact with you. Your whereabouts remain unknown.
Charge 2, obedience to the law.
Right, charge 2, on July 20th, 2024, you were arrested in the state of Pennsylvania by the Philadelphia Police Department. As a result, you were criminally charged with Statute 18-2701, simple assault, and Statute 18-2705, recklessly endangering another person. You were arraigned on these charges under docket number MC-51-CR-0013927-2024. Based on your behavior, you are in violation of your parole condition, obey all laws, will obey all laws.
And charge 3, travel.
Charge 3, on July 20th, 2024, you were apprehended in the state of Pennsylvania by the Philadelphia Police Department. On November 20th, 2024, your extradition to Connecticut was ordered by the Court of Common Pleas in Philadelphia, Pennsylvania. Based on your behaviors, you are in violation of your parole condition. Travel will not leave the state of Connecticut without the prior written permission of my parole officer.
The state has filed the following exhibits, starting with Exhibit A.
Exhibit A, Connecticut parole conditions. Exhibit B, IKS application. Exhibit C, compact action request, Connecticut to Delaware, dated May 31st, 2024. Exhibit D, compact action request, response Delaware to Connecticut, dated June 12th, 2024. Exhibit E, compact action request, Connecticut to Delaware, dated June 18th, 2024. Exhibit F, IKS violation report requiring retaking. Exhibit G, IKS case closure notice. Exhibit H, Bridgeville Police active warrants. Exhibit I, notice of parole violation. Exhibit J, parole violation report. Exhibit K, remand to actual custody order. Exhibit L, waiver of extradition. Exhibit M, Philadelphia Police Report, case number 24-26-036131. Exhibit N, Municipal Court of Philadelphia County Criminal Docket Detail regarding docket number MC-51-CR-00139272-2024. And finally, Exhibit O, Pennsylvania Extradition Order.
The state has filed an addendum to Exhibit G. Oh, sorry. Go ahead, Liza.
En el cargo número 1, fuga. Usted estuvo en contacto por última vez con Probación de Delaware en mayo 2 del 2024 al momento de una visita a la oficina. En aquel momento, usted estaba residiendo con su madre y padrastro en Bridgeport, Delaware. A usted se le indicó que regresara a otra visita a la oficina el 20 de junio del 2024. Usted tuvo contacto con la policía de Bridgeport en mayo 9 del 2024 debido a una disputa doméstica. El 3 de junio del 2024, su mamá se reportó con un intérprete a la oficina de probación e informó que ella contactó a la policía nuevamente debido a sus amenazas. Se emitieron órdenes el 29 de mayo del 2024 y el 30 de mayo del 2024 por amenaza. El 12 de junio del 2024 se hizo una llamada de seguimiento a su mamá. En ese momento, ella informó que usted ya no estaba viviendo en su residencia y que su paradero era desconocido. Ella creía que usted estaba en el área de Georgetown, pero no pudo proporcionar detalles adicionales. Una visita domiciliaria fue llevada a cabo el 1 de julio de 2024 a la residencia reportada, pero Delaware no pudo hacer contacto con usted, por lo tanto, su paradero sigue desconocido. En el cargo número 2, obediencia a la ley, el 20 de julio del 2024, usted fue arrestado en el estado de Pennsylvania por el Departamento de la Policía de Filadelfia. Como resultado, usted fue acusado criminalmente con Estatuto 18-2701, agresión simple, y Estatuto 18-2705, poner en peligro a otra persona. Usted fue procesado en estos cargos bajo el expediente MC-51-CR001397-2024. Basado en su conducta, usted está en violación de su condición de libertad condicional, obedecer todas las leyes. Yo obedeceré todas las leyes. En el cargo número 3, viaje, el 20 de julio del 2024, usted fue detenido en el estado de Pennsylvania por el Departamento de Policía de Filadelfia. En noviembre 20 del 2024, su extradición a Connecticut fue ordenada por el Tribunal de Causas Comunes en Filadelfia, Pennsylvania. Basado en su conducta, usted está en violación de su condición de libertad condicional viaje. No dejará el estado de Connecticut sin previo permiso escrito del mi oficial de libertad condicional. El estado también ha provisto la siguiente evidencia para fines de identificación: exhibición A, condiciones de libertad condicional de Connecticut; exhibición B, aplicación de IKEOS; exhibición C, petición de acción de Compact de Connecticut a Delaware con fecha del 31 de mayo del 2024; exhibición D, petición de respuesta de Compact de Connecticut a Delaware con fecha del 12 de junio del 2024; exhibición E, petición de acción de Compact de Connecticut a Delaware con fecha del 18 de junio del 2024; exhibición F, reporte de violación de IKEOS requiriendo ser retomado; exhibición G, aviso de cierre de caso de IKEOS; exhibición H, orden activa de la policía de Bridgeport; exhibición I, aviso de violación a libertad condicional; exhibición J, reporte de violación a libertad condicional; exhibición K, orden de regreso a custodia; exhibición L, renuncia a la extradición; Exhibición M, reporte de policía de Filadelfia, número 24-26-036131. Exhibición N, detalle de expediente criminal de la Corte Municipal de Filadelfia, número MC-51-CR0013927-2024. Y exhibición O, orden de extradición de Pensilvania.
The state has filed an addendum to Exhibit J, which states on November 26, 2024, Mr. Ortiz appeared in the Municipal Court of Philadelphia. Mr. Ortiz was found guilty of simple assault and sentenced to 6 months probation with costs and fees totaling $995.25. The charge, recklessly endangering another person, was withdrawn under docket ending in 2024.
El Estado ha sometido el siguiente anexo, el cual es la exhibición J, el cual indica que el 26 de noviembre del 2024 el señor Ortiz compareció a la Corte Municipal de Filadelfia. El señor Ortiz fue encontrado culpable de agresión simple y sentenciado a 6 meses de probatoria con costos y cargos totalizando $995.25 centavos. El cargo de poner en peligro a otra persona fue retirado bajo el expediente que culmina en 2024. En diciembre 18 del 2024, Mr. Ortiz fue regresado a Connecticut.
Mr. Ortiz, did you receive the notice of parole violation, and the other documents that were marked for identification purposes? It should have been a parole package that you received at the time you were brought back into custody.
Mr. Ortiz, ¿recibió usted el aviso de violación a libertad condicional, el reporte de violación a libertad condicional y los otros documentos que fueron marcados por propósitos de identificación? Es un paquete que se supone usted haya recibido cuando usted regresó a custodia.
Sí.
Did you have time to review it?
¿Usted tuvo tiempo para revisarlo?
Sí, sí.
Today we have no witnesses, and at this time the state will have an opportunity to present evidence and speak to any of the evidence submitted.
We do not have any additional evidence, officers.
No tenemos ninguna evidencia adicional en el día de hoy.
Would you like to speak to the parole charges? Okay. Mr. Ortiz, it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify today?
Mr. Ortiz, esta es su oportunidad de testificar o responder en relación a los cargos de la violación de libertad condicional. Sin embargo, usted también puede permanecer en silencio si así usted lo desea. ¿Desea testificar algo?
Sí, sí, yo sé que lo que yo hice, lo hice mal, ¿viste? Lo que pasó entre mi padrastro y yo es mi mamá. Yo tengo que defender a mi mamá en cualquier cosas que pasaron entre mi familia. Y entre mi padrastro y mi mamá, ellos discutieron y yo, como todo hijo, yo no puedo ver a mi mamá discutiendo con alguien, ¿viste? Y me metí. No se supone que no me metiera porque estaba en Parol, pero es mi mamá, ¿viste? Yo la tengo que defender, ¿entiendes?
So I know that I was wrong, and what happened was that it was an argument between my mother and my stepfather, and I know that I was not supposed to get involved because I was on parole, but she's my mother, so I was just trying to defend her.
Anything further?
¿Algo más que desea añadir?
No, yo estoy, me siento tranquilo, ¿viste? Estoy bien, estoy trabajando aquí en la cocina, estoy bien, me siento bien.
No, I feel okay. I am doing good. I'm working in the kitchen. I am okay.
Okay, thank you. And officer, nothing further, correct?
Nothing further. I would just like to add, I don't have anything further. I didn't have much time with Mr. Ortiz. He was released to parole on April 23rd of 2024 and absconded on July 12th of 2024. So he was only released to supervision for a period of 3 months. And like I said, that was entirely in Delaware. So we didn't have much interaction during his time on parole.
Yo solamente quería añadir que básicamente no tuve mucho tiempo de trabajar con el señor Ortiz, ya que él fue puesto en libertad condicional en abril del 2024 y hasta julio del 2024, y esto fue en el estado de Delaware, por lo tanto no tuve tiempo de trabajar con él, fueron solamente 3 meses de supervisión.
And Mr. Ortiz, anything further you would like to add before I announce my findings?
¿Algo más que usted desea añadir antes de que yo anuncie mis hallazgos?
No, yo tengo, como te digo, yo estoy bien con mi mamá, yo hablo todos los días con ella por teléfono, con mi padrastro, y me disculpé con ellos, ¿viste? Lo que pasó entre ellos y no me vuelvo a meter más nada. en esos problemas, ¿viste? Como le di a ellos por teléfono, como siempre le digo a ellos, ¿viste? Cuando se van a discutir, me hacen para el cuarto, nunca lo dan al frente de sus hijos, ¿entiendes? Y nada, y que si me dan una oportunidad con una fea o algo, se lo voy a agradecer, ¿viste?
Just want to say that I am okay with my mother and my stepfather. I speak to them on a daily basis and I apologize to them. And I will not get involved again if there's any other arguments. I would just advise them that if they are going to get into an argument, to not do it in front of the kids. And I will just appreciate if I get the opportunity to be released again.
Thank you. Regarding charge 1, absconder, I make a finding based on state's exhibits A through H and J. On charge 2, obedience to the law, I make a finding based on Mr. Ortiz's conviction, as well as state's exhibits A, B, J, M, and N. And on charge 3, travel, I make a finding based on state's exhibits A, B, J, M, and O.
Ahora le notificaré mis hallazgos en el cargo número 1 de fuga. Hago un hallazgo basado en la evidencia del Estado A, H y J. En el cargo número 2, obediencia a la ley, hago un hallazgo basado en la convicción del señor Ortiz, además de la evidencia del Estado A, B, J, M y N. En el cargo número 3, viaje, hago un hallazgo basado en las evidencias del Estado A, B, J, M y O.
That concludes the fact-finding portion of this hearing. Before I make my recommendation, both you and the state will have an opportunity to speak to your background and history. And when I say background and history, I mean future plans for parole reinstatement, and if you would like to discuss if you were working or what you were doing in the community prior to coming back into custody.
Esto concluye la porción de investigación de hechos de esta audiencia. Antes de hacer mi recomendación, usted tendrá la oportunidad de hablar de sus antecedentes, historia o de planes futuros. Si usted llega a ser puesto nuevamente en libertad condicional, si tiene alguna oferta de empleo, residencia, etc.
McCarty, do you wish to make a statement regarding Mr. Ortiz's background and history at this time?
I do not.
Okay.
Thank you.
Thank you. Mr. Ortiz, do you wish to make a statement at this time regarding your future plans or past, what you were doing if you were working in the community prior to remand? Would you like to make a statement?
¿Desea hacer algún comentario en relación al futuro, planes que usted tenga, si usted estaba trabajando anteriormente cuando estaba en la comunidad?
Sí, estaba trabajando en Simon Company de food en Delaware, que mi mamá me consiguió el trabajo, que estaba trabajando en la compañía, ¿entiendes? Y pues ahora pues que en un futuro, pues, si mi mamá me dijo que si el Parol me lo da para ir otra vez en un futuro, pues que hable con ellos, con los del Parol, porque ella me dice que me acepta otra vez en la casa de ella. Y nada, y si me dan una oportunidad aquí en Connecticut hay muchas oportunidades en Connecticut también, mira, en todos lados, que nada, conseguir un trabajo y seguir hacia adelante y seguir con mi programa de metadona, que tiene el programa de metadona, de droga y tal, y nada, y saltar de terminar. Tranquilo.
Okay, I was working in Delaware. I was working, it was a job that my mom helped me find. If I was to get parole again, she is willing to sponsor me again if it's necessary. And if not, I can find other options here in Connecticut. And I just want to keep taking my treatment for methadone and for drugs.
Mr. Ortiz, I just want to make you aware, I understand that your mom is willing to sponsor you, but you wouldn't be able to apply again for interstate for at least 3 months and with no, like all good behavior. And then you would again have to apply with your parole officer. So you would have to remain in Connecticut for at least 3 months before reapplying.
Mr. Ortiz, quería que usted no podría regresar a aplicar, a hacer una aplicación de interstate al menos 3 meses después que esté en Connecticut sin problemas de conducta. Tendría que volver a someter la aplicación nuevamente luego de 3 meses.
Ahí, sí.
So what area in Connecticut would you need a halfway house placement?
¿Te necesita una ubicación a una halfway house?
Sí, porque no tengo donde vivir aquí en Connecticut, no tengo donde vivir. No tengo
have any family nowhere to live here in Connecticut.
And do you have a particular area you want to be placed in Connecticut?
¿Algún área particular que desearía ser ubicado en Connecticut?
En Waterbury.
Any job opportunities in Connecticut, or you're going to have to look upon parole reinstatement?
¿Alguna oportunidad de empleo en Connecticut o tendría que buscar al ser puesto?
No, porque yo Yo trabajaba en una compañía que se llama Norpaco, que queda en Berlín. Y esa compañía, como yo trabajé para ellos, ella es una compañía de comida, de hacer galletas ricas, queso y bregar con entremeses, pues ya ellos me conocen que a la vez que yo aplique con ellos me cogen otra vez.
I was working before in Berlin, Connecticut. It was like a food factory, and they will be willing to take me back if I apply.
Okay, thank you. And I just have one more question for you. When you were arrested in in Philadelphia in July 2024, I'm sorry, in 2024, were you released from custody or have you been in custody since July 2024?
Mr. Ortiz, tengo una pregunta. Cuando usted fue arrestado en el estado de Filadelfia en julio del 2024, ¿a usted lo liberaron o usted ha permanecido en custodia durante todo este tiempo?
No, cuando yo estaba, llevo 7 meses preso. Llevo 7 meses preso donde me arrestaron en Filadelfia.
I've been in prison for 7 months since I was arrested in Philadelphia.
So you have not been in the community at all since July 2024?
Usted entonces no ha estado fuera de la comunidad en ningún momento desde julio del 2024.
Sí, estuve, cuando salí de Connecticut, que me enviaron para Delaware, estuve como hasta julio en la libre comunidad y después me busqué el caso en Filadelfia, que estaba viendo en una hermana mía que iba en Filadelfia, y ahí fue que me busqué el caso y desde el 20, yo creo que fue el 20, fue un domingo que me arrestaron, pero no me recuerdo si fue 20 o 19 por ahí, o 21, pues eso fue domingo. Yo creo que entre el 20 o 21 del 2000 de julio, y desde ahí para acá pues estoy confinado, llevo 7 meses confinado.
Yes, the only time that I was out in the community was when I transferred from Connecticut to Delaware, and then I got the case. I think it was on a Sunday, 19th or the 20th of July. I cannot remember. I know that I went to see my sister, but since this time that I was arrested, I've been in prison.
Okay. Anything further, Mr. Ortiz?
¿Algo más que desea añadir, señor Ortiz?
No, yo estoy agradecido con el trabajo de mi trabajo de Parol, que yo sé que ella está empezando conmigo poco, no tenemos mucha comunicación y nada de eso, pero en un futuro me gustaría hablar cosas, planes como ella me puede ayudar en la libre comunidad, como en mi supervisión, como cuando después que salga de afea o algo, que consiga un lado donde vivir o algo, ¿viste? Y nada, estoy contento, ¿entiendes? Yo soy culpable de las cosas de mis errores, ¿entiendes? Y nunca he hecho para atrás, que veo, ir para hacia adelante y nada, agradecido.
Okay, I just wanted to say that I am grateful for my parole officer. I know that I didn't have a lot of communication with my supervising officer because there was not a lot of time. But then I just wanted to say that I am willing to work with my parole officer, and then after I get released from the halfway house, maybe I can get an opportunity to get my own place, and I am happy and I am grateful.
Okay, thank you. And also, anything further?
No, if I could just say, in the future on parole, you have a long time left. Talk to your parole officer. Your parole officer is here to help you. If you have stuff going on, if you're involved in things like this with your mom, just call. It's better to call than to run, because we can help you as long as you're in good standing.
Quería mencionarle que en el futuro, si esto llega a suceder, es importante que usted se mantenga en comunicación con su oficial de supervisión si llega a tener algún problema, y que tengan esta comunicación. Es mejor que hable con ellos y no decida huirse, porque mientras usted se comunique con ellos y hable con ellos, siempre lo podemos ayudar.
Está bien.
And P.O. McCarty, for the record, are you aware of how long Mr. Ortiz has been in custody?
It is my understanding, based off of the report added by the fugitive unit, that it appears that when he was arrested in July of 2024, the fact that they noted he was apprehended by Pennsylvania and then extradited in November back to Connecticut, it would appear that he was in custody since that time. But again, I would deny that. I wasn't there for it, but that was what it appears.
Okay, thank you.
Yeah.
And more, Mr. Ortiz, you're all set. Nothing further before I make my recommendation, correct?
Mr. Ortiz, sería todo antes de que haga mis recomendaciones.
No, agradecido, nada, y estoy tranquilo, sí, estoy bien, gracias, y es.
I'm just grateful and I am okay, thank you.
I recommend revoke and reparole on February 27th, 2025, which is an approximate 2-month sanction from when you return to custody in Connecticut. However, being that you have been apprehended in the state of Pennsylvania since July 2024, it's a total of 7 months that you've been in custody. And I recommend the following conditions: anger management, no contact with victims ES and JS, a general no contact with ZO without the express permission of your parole officer, halfway house placement, and mental health treatment.
Yo recomiendo que se revoque su libertad condicional y que sea restablecida nuevamente el 27 de febrero del 2025, lo cual es un periodo de sanción de 2 meses desde que usted regresó a Connecticut. Sin embargo, Mr. Ortiz fue detenido en el estado de Pennsylvania en julio del 2024, lo que totaliza 7 meses en custodia. Además, recomiendo las siguientes condiciones: manejo de ira, no contacto con la víctima ES y JS, no contacto en general con ZO sin el permiso expreso de su oficial de supervisión, ubicación en halfway house y tratamiento de salud mental.
My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on February 27th, 2025.
Y hallazgos y recomendaciones se emitirán a la Junta. Usted recibirá una decisión oficial por escrito y esta revisión de la Junta está programada para el 27 de febrero del 2025.
Being that you're on special parole, and my recommendation is for February 27th, if the board agrees with my recommendation, you will be released on February 27th, 2025. If the board does not agree with my recommendation, since you're on supervision until September 2034, they can exceed my recommendation. And if they do, then a supplemental hearing will be provided to justify additional confinement.
Debido a que usted está en supervisión especial de libertad condicional, si la Junta está de acuerdo con mi recomendación, usted sería puesto en libertad ese mismo día, el 27 de febrero del 2025. Si ellos no están de acuerdo, ya que usted está en supervisión hasta septiembre del 2034, entonces se haría una audiencia suplementaria para especificar las razones de algún confinamiento adicional.
Okay, Mr. Hernandez, any questions or Ortiz? Because we're all set.
¿Alguna pregunta? Sería todo.
Es muy importante lo de la salud mental. Yo estoy cogiendo tratamiento de salud mental, con medicamentos y eso, que estoy cogiendo aquí tratamiento también de salud mental.
Just wanted to say that the mental health is important and that I am going through treatment and I am taking medication here at the facility for my mental health.
Okay, thank you. So your hearing is concluded. You're all set. Thank you very much.
Sería todo. Ya terminó la audiencia.
Have a great day.